And one of the things that I would like to mention to everybody is that in the past, what we see is that people join the sidebar, what is that called?
Chat,
The
chat.
chat group. And and then all of a sudden I'm realizing that all these conversations are going on in the sidebar in the chat room because people want to help or they want to share information or they want, that type of thing. And then they ask the very question about what Gail and I just talked about. So it doesn't really work. So if you would, as much as possible, please refrain from carrying on sidebar conversations while the presentation is going on. If you have a question that, you could always type it in there, and then at the end of the meeting, we'll do our best to answer all your questions. Okay? So again, today's class is a guide for family that have a conservatorship on somebody that's LPS conserved, and it's going to be excuse me, presented by the Public Guardian's Office, Cashmere, who you've just been introduced to, Gail, Evanguelidi, and of course myself from Jim Farell. I want to make it really clear in your understanding that LPS conservatorship laws apply to every county throughout the entire state of California. So some of you might be outside of NAMI urban Los Angeles, even though this is really focused for Los Angeles. What we're going to teach you here actually is applicable to the entire state of California. So that being said, Araceli, can we have the next slide? There we go. So special thanks go out to Maddie Cobb Brown. She's with NAMI Urban Los Angeles, as is Harold Turner, who's the president of NAMI Urban. And Araceli, she's running the meeting for us today. You guys are just awesome, and we so appreciate your support and everything. Next slide. So we're not attorneys. What we tell you is not coming across as this is the law, but what we're sharing with you today is what we've learned along the way. And we try to give you the greatest probability for success and recovery for your loved one. We make suggestions. Ultimately, nobody knows your loved one like you do. You make that final decision on what you feel is the right path for your loved one. We just hope that what we present to you will be of value to you as well and make things better for all concerned. So that being said, I think we've covered this slide. Let's go on if we may. So whenever you're talking to the hospital, psychiatrist, anybody that has anything to do with your loved one that's on conservatorship, always refer yourself as a conservator. It's not like, hi, I'm Mr. Jones, I'm Mrs. Smith. Just say, hi, I'm Stephen's conservator. And that always sets the stage for your authority and your position and why it's so important for you to be having some level of communication with them. It's very, very highly recommended also that you take the free NAMI family to family class that NAMI Urban Los Angeles is offering. It's just really going to broaden your understanding of what's out there in terms of resources and what your responsibilities are. As you're going along as a new conservator, you'll want to keep two journals. One is going to be for the medications, and it says with your observations. What that means is that your let's say your psychiatrist has just prescribed a new medication. At that point, keep in mind that it's very important for you to keep tabs on the behaviors of your loved one. Do they have greater clarity of cognizance? Are they less upset than normal? Are they, gaining maybe some insight into their illness, that type of thing? Or if it's just not doing anything at all, but just making them sick and so forth. You need to keep track of these things in a journal so that when you meet with the psychiatrist or whoever next, you'll be able to share with them your observations. Also, anytime you talk to somebody, irregardless who it is, and if it's concerning your conservatee, write down in your book who it was that you spoke to. On this date, at this time, I spoke to so-and-so regarding that type of thing. And then thirdly, get involved. Get to learn who your legal representatives are on local and state levels. and let them know your feelings. Send your thoughts to them, and if you have information about how something should be changed within the law, see if you can get them to work with you on that. Okay, so next slide. And I'm very sorry, I can't see. It looks like this one's for Gail.
No, it is. Okay, LPS conservatorship. That's the legal term that they use in the state of California for involuntary mental health treatment. Different states have different terms. Some will use guardianship, some will use conservatorship. Florida does Baker's Act reform, Louisiana does an interdiction, and they have different terms throughout the country. Their laws are always different. In the state of California, you do not want a guardianship. A guardianship means you are responsible financially, you're liable for criminally, financially, anything they do. Under the involuntary mental health, the LPS conservatorship, if you choose to be the conservator, you are not liable legally or criminally for anything they do unless you're negligent. And we'll talk about that as we go on with the program. These laws were from 1974, and they really they're in the California Welfare and Institutions Code 5200. They're over 50 years old, and they really don't reflect the scientific research that can help a person regain their lives. Now, recently, as of January 1st this year, some of the laws have been changed, particularly gravely disabled, the definition of that. And we're going to go into all that. So it will help you. But we're going to give you things to be cognizant of, what to say, what not to say, and why. Okay, next slide.
It's for me.
Yes.
Okay, so information for conservators. Um, there are booklets given to private conservators to assist them with knowing what to do and how to do certain things. We have a booklet located on our DMH website. If you are to go to the DMH website, I believe it's under the R Services tab. You'll find the Public Guardian, and under the Public Guardian, there's a booklet for helping your loved ones, a guide to conservatorship and involuntary treatment. The book, I wrote some notes so that I didn't forget anything. Um, it's a good resource for private conservators because it explains conservatorship and the duties of the conservator. What to expect from the treatment team. It explains placement. What do you need to report to the courts? It explains how to manage finances. Also, there's forms that you may need to provide to the court or that you may need in general during your conservatorship. Those forms are also listed in the booklet. That can be a good resource for private conservators.
The essence of the conservatorship is it mandates medication. It takes away certain rights temporarily, but you can get those rights back. But the whole purpose of the LPS conservatorship is to mandate medication. And if you want your loved one to be able to think clearly, they need certain chemicals in their brain so the neurons will be able to connect properly. And that's what you want. And yesterday, when we had the meeting yesterday, James Kwan was talking about something. He was talking about conservatorship, that basically what they do on the LPS conservatorship, the intent is to get the person so that they're no longer gravely disabled. Our intent in these classes is to get your loved one back to where they were as close as possible. And that's where working on the medication is extremely important. Keep that journal. That journal helps you and it helps the doctors. Okay, next slide.
So mental health court department A and B. Our conservatorships are heard in Norwalk Courthouse in departments A or B. It's located at 12720 Norwalk Boulevard. That's in Norwalk, 90650. We have a new judge. I hope I'm not saying her name wrong. Anastasia Sukhanova.
That sounds good to us.
That was kind of close. And Judge Renee Gilbertson. So those are where our matters are heard.
Yeah, I have a statement on this to ask. Because we have a new judge, and apparently she came from Orange County, and she was a public defender who defends the client. If they say, I don't want the conservatorship, that was her job. So if y'all go to court and you have her, if you can give us some feedback, we would appreciate that on the judge, how she does.
Yes.
Okay. And we'll give you some tips too when you go to court, what they're looking for. Next one. The types of LPS. Now, this is LPS conservatorship, different than probate conservatorship. Don't get them confused. You have two types. You have the conservatorship of the person and the conservatorship of the estate. You cannot have conservatorship of the estate unless you have it of the person. It is the treating doctor at the hospital, jail, or if there's a program that's doing it, who initiates the conservatorship of the person. You cannot initiate it. Most information in this class will pertain to the conservatorship of the person. If you need a conservatorship of the estate, and don't think that they have to be billionaires, millionaires, or any other such thing, you can, when the public guardian is petitioning to get the conservatorship, and you can do this anytime during the year if you feel like you need it, you can ask the public guardian to help you acquire the conservatorship of the estate. And sometimes I suggest to people to run creditkarma.com. That way you'll know what debts they owe. You do not use your money to pay those debts. If they have the money to pay the debt, sometimes you can negotiate 25 cents on the dollar, 10 cents on the dollar, and you tell the company, the credit card or whatever, hey, look, I've got this amount of money. I can give it to you, but I want you to send me in writing, this debt has been paid in full. If you don't have the money, don't stress. They'll do a judgment against your loved one, but after 3 years, that comes off the credit report. So I would not get too anal about that. It is not the doctor who is involved in the conservatorship of the estate. Now, Cashmere, do you want to say something about the public guardian and the conservatorship of the estate?
Let me think.
Yeah, you all you take over the conservatorship of the estate if the public guardian is a conservator.
We do. So we will be responsible for, if the client is receiving any income, for making their care payments or providing them with personal money for personal needs, food they may want, just any personal incidentals. So we are responsible for the client's estate. And also if it doesn't happen that often, but if there's property or vehicles or personal property, we would also be responsible for managing that.
Okay, next slide. Thank you. Succession of conservatorship. You can change the succession of the conservatorship. That's where, let's say you choose to be the conservator at the beginning and you get 2 months down this and you go, I can't do this. You can petition the court and you can change this back to the public guardian. But likewise, if the public guardian is a conservator and 2-3 months down the road you go, I really want to be the conservator, you can petition the court. You just write a letter to the Norwalk Mental Health Court, A or B, for a succession so that, and it takes like 7 to 10 days to get this done, for you to become the conservator. And there's reasons why you might want to be the conservator. Cashmere, did you want to add anything on this?
No, I think that was
okay.
Information.
Yeah. You don't have to wait for the whole year at the end of the year to do this. Next slide.
So who should be the conservator? If the public guardian's office is going to take over the conservatorship, the pro is that they'll be able to place the person in a state-approved facility, like one of our state mental health hospitals. Also, there's a lot less stress for the family, especially for those that are suffering from a co-occurring illness, let's say they have substance, I don't know what's wrong with my tongue today. If they have substance abuse issues, they may be constantly asking for money and that type of thing, and you're just so stressed about giving them any money at all for fear that they're going to go out and spend it on things they shouldn't be spending it on. So if the public guardian's office is, overseeing that, that's one less stress that you're going to be looking at. You have also less involvement in the recovery process. You also, as a family, will not have any control over the medication, and working to establish a good relationship with the public guardians, it's best to email their public guardians with information. They have such a high caseload that they don't have time to sit on the phone and talk about your conservatee. So email, I think, is very respectful and sharing with them information that you feel is necessary for your loved one's care. Next slide.
Well, can I just add something on that with the conservator? Be respectful. If the public guardian is the conservator, their main goal is your loved one. And they have to go out. They have 50 to 75 people they're dealing with. They have to go out so often to go visit face to face to see them. And when they're in the field, they do not want to be on the phone working with you, talking with you, that sort of thing. So they tend not to respond at that time. But if you send them an email, they will tend to respond a lot easier. Okay, next slide.
So you're new to being a conservator, or you're considering on being a conservator. You think, well, do I really want to take on that role? So if you are the conservator, you're going to have direct contact with the doctor. You can reject inappropriate treatment facilities, medications, and treatment places. So in talking with the doctor can share with you as a conservator what medications that they're on. You can then have report, and we'll talk about this later. You can share back, information to the doctor in regards to how you perceive the medications as working or not working and that type of thing. As well, if there are, let's say, if there's a treatment facility or something that you feel is not appropriate for the care of your loved one, you can reject that placement as well. The downside is, as I mentioned earlier, the conservative really manipulates you. They try to get you to do things for them that you just don't want to do, and you know that if you do something for them that they're asking for, like giving them money and other things that are not normal money amounts and so forth, it's just a lot of stressor to have to keep saying no. But that goes with the job. So the negative again would be that the hospital will try to push you around and discharge your conservative to a facility not appropriate for the level of treatment needed for recovery. Yesterday I talked about this. My conservatee was in one of our Orange County hospitals, and they are by law required to first contact me if they feel they need to transport him to another facility. And also by law, I, as the conservator, have the right to go to that facility and see if it's an appropriate location or if the program that they're offering is appropriate for the level of needs of my conservatee. And they cannot just move him over there. If they do, which has happened to me, I get on the phone, let them know they just stepped in it, and they have to bring him back to the facility or to a facility that I approve of. And I made them do that because they were in violation of law. So again, that's what's been explained to us by attorneys, and not something that I'm just talking about off the top of my head. So I'm just passing that information forward. Next slide, please.
The liability for the conservator, the law, and that's the law up there, 5358.1. That's in the California Welfare and Institutions Code. You are not, by law, liable either civilly or criminally for anything the conservatee does, may or may not do. Now, if the courts have taken away their right to drive a car, and you give them the keys to the car and say, could you just run up to the store real quick and get some milk, and they have an accident, you are liable then because you were not acting in good faith. But If they took the keys to the car and had an accident, you are not liable. You are also not financially responsible for any of their debts. So put your money away. This is really important. Um, People want to tell people, oh, I got money, I can pay for this. Well, unless you're a multimillionaire, kiss your retirement, your vacations, everything goodbye, because they will suck you dry. And because your loved one is over 18, then the county will handle all these situations. So don't jump in and say, well, I'll pay for this or I'll pay for that. Because the moment you do, they're going to start using your money. Cashmere, did you want to add something to this?
You pretty much covered it, but just this is based on, of course, the assumption that we're following the court's order. So as long as we're doing what we're legally responsible to do, then we can't be held liable.
Right. Jim?
Well,
No comment?
my experience has been that I have a conservatee that's dual diagnosed, and when he imbibes in things that he shouldn't be putting into his system, sometimes it gets a little bit violent, and he's caused thousands of dollars in damage in board and cares in the past. And I knew that I was not liable for that, but I also didn't want the doors to slam on my conservatee for future care. And so I saw to it that those expenses were covered. And you know, the groups, the board and cares have a state association and a county association, and they all get together, and I'm told they swap stories on, now if you get this one in your room, you know, you don't want them in there. So I tried my best to take care of that, even though I wasn't liable for it. So just use your best judgment on what you feel should be done.
In that case, you can spend your money. Next slide.
Right.
The rights and responsibility of the LPS conservator. Your powers are to approve or disapprove all medication, treatment, and placement. So if you have a psychiatrist that's going to prescribe 8 medications, you want to tell me which one's really working? Because every medication, including aspirin, comes with side effects. So you want to find one medication that works the best at what level. And unfortunately, and we're going to go more into this, it's trial and error. They don't have like if you have a bacteria, they have a petri dish, they can grow the bacteria, try different things and decide, okay, which antibiotic do you need? When it comes to psychotropic medications, we're not there yet. Now you have people that say, oh, well, we can take their DNA and we can find out what medication's going to work or what medication's not to give them. I've not heard anybody that has really success with that. In fact, I've heard that when they do that, they say, don't give them this, don't give them that. Well, guess what? That was the one medication that did work. Treatment. The therapist, you have a right to say, hey, we're not going to use that therapist, because the therapist might be telling them things that you don't want. They might be saying, well, they need marijuana to calm the voices. Yes, marijuana does calm the voices, but what it does, it comes back and they makes them more agitated, irritable, to the point they become violent. They end up in jail. So, and there are therapists that they're doctors that want to say, oh, I'm going to prescribe marijuana. I would stay far away from that. Placement. That's another thing. You know your loved one better than anybody. So when the hospital or facility says we're going to transfer him to a certain placement, you go out and you check out that facility, ask questions. You want to know about the treatment, about the therapy. If they go off their meds, are they going to let you know? You want to know a lot of things. You want to also have your list of questions and put in that list of questions, how do you handle sex? You don't want them coming out of a treatment facility and you are now a grandparent. So be cautious of things like that. But your power, keep in mind, this is the basis of your power to approve or disapprove. You don't have to go look for facilities. You don't have to look for the doctors or prescribe the medications. You're not, you can't do that. But you can say no to some medications. That's why that journal on medications is vital. Keep that. Anybody want to add anything, Jim? Cashmere?
You've covered it.
Next slide. The conservators have a right to speak directly with the treating doctor. And that is a powerful thing. Now, don't drive that doctor nuts. Keep in mind, he's got other people. If you can go through the social worker or the charge nurse, do that. But if you need to speak directly with that doctor, that is your right. So do it. When you speak with the doctor, keep a bullet of what you need to ask him. Don't start going into, well, when they were 2, they did this, or 5 years ago, they did this. They don't have time to listen to all that. Get right to the point. What is your problem? What do you need to do? As a conservator, you can apply for SSI, SSDI, Medi-Cal, Medicare, and VA benefits. And yesterday we said when you go to Social Security, you don't say, I am applying. If you are the conservator, yes, you can, because you can sign for it now. And that makes a big difference. By the way, you can also have private insurance, Medi-Cal, and Medicare all at the same time. And private insurance will pay for many of their services. So when somebody tells you, well, you have to get rid of your private insurance, no, you don't. Okay, anybody want to add anything to this? Okay, next slide. Silence is golden. I love that. California Welfare and Institutions Code 5358.5 is extremely important. If your loved one goes off their medications, do not wait for them to decompensate to harm to self and harm to others. I don't care what anybody tells you. You don't have to wait. The law, it says, as conservator, when you deem it's necessary, you have the right to have your loved one transported to the hospital. If they go off their medications and they're off their meds for a week, you can contact the police. I would go to the watch commander at the police station, give them 3 copies, a copy of your conservatorship, a copy of the law, and the law is in the Guide for Conservators, which is on the resource paper in NAMI Urban LA, and a written statement that you are requesting that the police transport your loved one to a hospital. Now, what does help them, if you contact their psychiatrist and tell them he needs to go back to the hospital, the psychiatrist can find a bed available. When the police know there's a bed available, it's an easy fix for them. They pick them up, drop them off. But if they have to wait for a bed to become available, they really don't appreciate that. But that is your right as a conservator when you deem it's necessary. And many times, if you do this right away, they can pop a pill for them or give them a shot, whatever they have to do, and they're good to go. The longer you wait, they may have to do a little R&R at the hospital. But if you wait for them to get really sick, now you're waiting for IMD beds or treatment beds or whatever you need. You don't want that to happen. So do not wait for them to decompensate. If you're having trouble with this, you can call me, Jim, or contact in the LA, Miriam Brown, she's the deputy for emergency and triage. I can't see the other word on that, but that's her phone number. So that is a powerful tool for you to keep them on the medications. All right, Jim and Cashmere, either of you want to add anything? Silence is gold. The next slide. Me again? Oh, no, next slide.
ADT. So the authorization to detain and treat needs to be submitted to wherever the conservatee is either being placed or being hospitalized. The form is just to let the facility know that you as a conservator or PG as a conservator has the authority to consent to treatment or for this person to be detained in that facility. The form, of course, should be filled out completely. The correct address and name of the facility where the client is actually going to should be there. It should be clearly marked whether it's an authorization to treat or to detain and treat. The conservatee's first and last name should be included on the paperwork. I believe their court case number, there's a space for court case number as well. And the powers that you're granted on your letters of conservatorship should be clearly marked. I think
their court case number, is that Z number
yes.
that they have? Is that what you're referring to?
Yes.
Okay.
So the number should be on there. And then if you have power 6, that lets them know that you have placement powers. Power 7 would be for a locked acute setting. And then the power 8 would be to consent to psych medications. So the ADT should always be submitted to each new facility that the client goes to.
Okay. Next slide.
So this is CalAble is a state-run organization that allows you to donate money to that will accrue over time. You can either have them hold the money just so that it's safe without it accruing any interest, or you can have them invest your money so that down the road there'll be monies available for your conservatee. Pros and cons on that is, how does that compare to a special needs trust? Because in CalAble, I'll give you a perfect example. My son had to be placed into a boarding care, and I certainly found one. In fact, it was excellent. But they were wanting more money than what Social Security was paying for. Consequently, I knew that if I used my own funds to supplement the difference, that would have negative impact from the Social Security office. So what I did was I took the difference in cost and I put the money into the CalAble account. Any monies coming back out of the CalAble account for my conservatee's need then will not jeopardize his benefits. So basically, as it says, this page lists the different disability-related expenses that can be paid for without losing their government funding. If you go to that website, if you just go to calable.com and Google it, it will give you an entire list of things that you can actually purchase for your loved one. Computers, training classes, a whole host of things that can be used that allow you to put your additional money out of your pocket into so that those monies then could be spent from the CalAble account and better enrich your loved one's life. So you might want to look into that. Next slide. Yeah, so these are some of the things that you can actually use those monies for. Employment, transportation, housing, things that you can't pay for directly, but through CalAble funds you can, and not jeopardize their funds. Next slide.
Wait, if I can just add, basically this is if you have SSI. If you have SSDI, you really don't have to worry about this. But Social Security will take, for every $2 you put in, they will reduce $1. So you really don't want to get involved with writing checks, supplementing certain things, because then they start taking the money away and then you have to add more money. You don't really want to do that. And keep in mind that if they're receiving SSI and they're single, do not allow more than $2,000 in their bank account at any time. Because if you do, it goes to $2,050. You very well might be audited. It's not a big deal because you can explain, well, this happened, but you don't need that added stress. So if you're looking and you go, oh, they've got $1,500 in there and it's time for more money to be added, get that money out of there. Whatever you have to do, just get it out. That helps. Cashmere, did you want to add anything to this?
No, that was pretty much it.
Okay. Next slide. The LPS conservatorship of the estate. And I had mentioned you can deal with things like this. If you need it, go to creditkarma.com. You know your loved one's Social Security number. Run a credit report. Find out what debts he owes. You can negotiate those debts, and you can do it 25 cents, 10 cents on the dollar if there is money to be able to do it with. If there isn't, don't worry about it. You can handle criminal court cases. You can acquire a waiver for school loans. And believe me, that's a big one. If they owe $50,000 in school loans and they're under the conservatorship, you can get a waiver. And if they're not earning, as long as they're in the poverty class for the next 3 years, that school loan is wiped out. You can also cancel credit cards, and that's very helpful. When you're at the court, at the mental health court, ask the judge to appoint you an attorney should you have any questions during the year, legal questions. The attorney's free, and you can call them and you can ask them for help should you have any concerns. You can always call me too. But keep in mind, I am presently on the East Coast and won't be back in California till probably July. So we're 3 hours ahead of you. Call me when you're having your cup of coffee in the morning. I'm a morning person, but don't call me at night unless it's an emergency. Okay, anybody want to add anything? Next slide.
Okay, so conservators must have court approval for all invasive medical treatment. With LPS conservatorships, they are for the treatment of mental health issues. So if there's ever any medical issues that arise, we do have to, or you, the public guardian as well as private conservators, do have to go to court, explain the procedures that are needed or whatever's needed, and the court has to then give us the authorization to approve those invasive treatments. And the court must be informed of all medical problems with the conservatee.
Okay, can you address what's the electric shock that they do on that court approval? The electric shock that they do if they're doing with the court, you need that approval for the electric shock to the brain.
Well, to that specifically, I'm not exactly sure, but I know that will be included. Anything like that will be included in needing medical treatment. Notify the court. I believe the letters from the doctor will be necessary. What is this for? What is it going to do? How is it going to help the conservatee so that they can have all the information that they need to make a decision regarding whether that should be approved or not. And that really goes for all invasive medical treatment, but that will be included.
Okay. Unless it's an emergency, that's different.
Yes.
Okay.
In emergency situations, while we still can't authorize that to take place, the facility, the hospital, wherever the conservatee is, they would have their own emergency protocol to where they would need to wait for us to go to court and get certain things put in place. They will be able to say, as a doctor, this is an emergency for either to save this person's life or we can't wait for this. And then they would sign off on that and complete that procedure without the conservator authorizing it.
Okay. Next slide. Ah, there you go.
So all non-emergency invasive procedures must be approved by Department A or B, like we kind of just talked about. So no experimental treatment is permitted for conservatees. Request all medical issues to be approved, of course, by Department A or B. Now, this can be it could take time to get these things authorized, and sometimes that becomes the problem. The conservatee's dentist may call saying that they need their multiple teeth pulled, and they need this to happen right away, and they're pushing and pushing. We cannot make that, or the conservator cannot make that decision without the court, and regardless of how long that may take. So it's just good to keep in mind that we do need authorization from the court for any medical treatment.
Yeah, that, if I can add, that is why you get that attorney. You can contact your attorney. If your loved one has a toothache and that tooth needs to be pulled, you can contact the attorney, and the attorney can usually get the approval that day. They just go in and ask for it real quick, and then you can get it. But if you have to go to court and request it, it's going to take you a lot longer. So be sure to ask the judge to appoint you an attorney when you're in court. If you're going to be the conservator. If you're not the conservator, they will not appoint an attorney. Okay, next slide. As a conservator, you have direct contact with the treating doctor, and it's under the California Welfare and Institutions Code 5328.1. The reason why we're giving you these laws is people will say, well, we can't do that. That is what the law is. When you're talking to people, you don't want to be rude or obnoxious, but you do want to be firm and stand your ground. And if you know what your rights are, you're more inclined to do that. You have the right for the prognosis, the medications, the side effect of the medications, and you have the right to have the direct contact with that treating doctor. But again, be respectful. You're trying to get a hold of the treating doctor, and if he goes, oh, Lord, that's another 2-hour conversation with these people, he's not going to exactly be answering his phone call, and he's not going to call you back at any time quickly, which you may need. If the doctor refuses to speak with you, okay, what you can do is contact Kayla Coates, who's a senior deputy director for DMH, that's her number, or Remy Hyundai, who's the chief deputy director of DMH, and they can take care of that for you. Or you can call me if you're having trouble, and we can get that done so that the doctors, because there are a few doctors that think that they don't have to talk to you, and we kind of educate them a little bit. All right. Anybody want to add anything to this?
No.
Next slide. Criminal court cases. Okay. Jim and I are going to be talking with James Kwan, who's the public guardian director or supervisor, because there's different thoughts on this. Okay. If you're dealing with a criminal court case, ask the public defender to request Department of Mental Health court linkage program to be involved in the case. They can open doors for treatment, so you really want them on board. You can request jail diversion or a misdemeanor diversion program. There's a whole bunch of these diversion programs. And when your loved one is in these programs, they're good for about 2 years. At the end of that time, depending on what their case is, the case may be dismissed or knocked down that it's nothing more than like a parking ticket or something like that. So being involved is very important. If they are under the LPS conservatorship, that's almost like your insurance policy that this person will be able to complete the program. Because if they go off the medication, zoom, back to the hospital. The hospital's the only place that can force the medications. Now, they're not going to hog tie them down, but they will work with them to give them the medications. So that's really helpful. But remember, I said that you have the powers to approve or disapprove treatment, placement, and medication. When it comes to placement, and it's through the criminal courts, the criminal court has the first right to place your loved one for treatment over your conservatorship. So anyone want to add? All right, next slide.
It's for me.
Yes.
Possible, it's a little small, so sometimes I'm trying to see PG. Possible treatment programs. So some possibilities, of course, include LPS conservatorship. Now, LPS conservatorship, of course, we know it is involuntary treatment. So with the listed programs here, it's either going to be LPS conservatorship or one of the others. The others, AOT, assistant outpatient treatment program. So by law, you can't have an LPS conservatorship, involuntary conservatorship, and then an AOT. It will be one or the other. We have a care court program, home team, which is the homeless outreach and outpatient. And then we have FSP, full service program. So it's just up to the conservator to figure out what the client's needs are and what's the most appropriate program for that person. So it could be a conservatorship, but it also could be outpatient treatment or care court or one of the other program options.
And I'd like to add, when they finish the LPS conservatorship, you can apply. You don't have to be a conservator. You can apply for care court so they can continue treatment. 'Cause a lot of times it used to be when the conservatorship was removed, it was like, what do we do? I mean, they have no more treatment place, anything. Care court can help them, and they can help them to get a facility to live in, keep their services, their resources going. They can do a whole lot of things and still come out and visit your loved one, get them in therapy, whatever else they need. So the care court is really a good program. And sometimes you can have care court and LPS conservatorship together. But before select which direction you want to go. But I always say it's like slinging the mud at the wall, whatever sticks you're going to take. Anybody want to add?
I was just going to add that even with my office, the public guardian, when we find that people are ready to terminate from LPS conservatorship, we even submit care court referrals so that they can continue on with some type of assistance once they're off conservatorship. So it can definitely be something that happens after conservatorship, if that's appropriate.
Right. It's a good program. It really is. And Linda Boyd, who runs it, is exceptional. Okay, next slide.
Okay, so in medications, you should know all the medications. Keep a journal on it, just like you have, you're going to be running more than one journal. You want to look at the side effects. What would be the normal dosage range? What is the doctor prescribing? And to research those medications, there's a website called drugs.com. It's the National Institute on Drug Abuse, NIDA, or ChatGPT. On drugs.com, they list all the different medications ever manufactured. They talk about the side effects. They discuss the normal range of medications and so forth. So if you see your doctor prescribing something way above a normal prescription dosage, as listed in this website, it may be an indicator that you would like to have a conversation with your doctor about that and why he's, so far above the normal dosage range. Again, all of this should go into your journal, the efficacy of the medications being prescribed by your doctor for your loved one, what's working, what's not. So keep this. This is really a great asset for all of you to keep on board. In terms of medication, what works for one doesn't necessarily work for everybody. So you want to, again, track that medication, how it's, working for your loved one. Write in your journal the date of the medications when they were prescribed, and you should have a goal is to find out the best medication for clarity of mind with the least side effects. Anybody else?
Yes. When it comes to medications, when it comes to these doctors, honestly, they're not gods. They may think they are, but they're not. So it's important for you to know these medications. The NAMI Family to Family class has a great class. I think it's their 8th class or one of them, which is on medications. And you do learn quite a bit. Don't think you have to, you go, oh my gosh, these medications, I don't know about it. Believe me, you can figure these out pretty quickly. And with the medication, you want to find out which one works the best at what level. Now, I'm going to go out on a limb here. It's basically, when it comes to these psychotropic medications, it's like and I mentioned this yesterday, if you have a migraine and I have a headache and I say, take my Tylenol, it'll help your migraine, it will not even phase it. Well, many of these doctors will prescribe medications that are good for a person who has a mental health problem. Your loved one has a serious mental illness, so you have to up the ante. So I'm going to give you a list. You can write this down, and I don't put it in here because it's just not a good thing to do. Invega, INVEGA, tends to work very well for people with serious mental illness. It does not work for everyone. I would say approximately the feedback that I get is about 80 to 85% that, whoa, it really helps. But keep in mind, I have that other 15% that, ooh, that was not good. So, and Invega comes with a shot. Now, Invega is the same chemical composition to risperidol, made by the same company and everything. It's how it's delivered in the system. Risperidol goes to the cell and all those organelles that you learned in biology in the cell. It goes to all of them. So they all send out little different messages. Invega goes more to the nucleus of the cell. So it's more clarity. If you're on Invega, and this is if it works for you, you tend to be more motivated, less tired. You may take a nap or something, um, less side effects. So it's one that tends to work pretty well. Another one is Latuda, Latuda. And I don't believe it comes with an injection, where Invega does. So does Risperidol. Another one is Vraylar, V as in Victor, Raylar. If you have a loved one that has the negative symptoms of schizophrenia, that's things that have been taken away from him. They're the walking zombie. There's no smile, no laughter. They just kind of go through the motions. Vraylar, there's only 2 medications that will help that I'm aware of. Vraylar is good. It's also good for the positive aspect of schizophrenia. That's the entertainment that you get, the hallucinations, the visuals, the verbals. That's all the entertainment. That's positive schizophrenia. But Vraylar, to my understanding, it still does not have an injection. I think they are working on it, but that's one of them. 2 others, Caplyta, Caplyta. I understand the doctors are now in California starting to suggest that one. And in Florida, they do quite a bit. And they have pretty good success with it. Another is Cobenfy, Cobenfy. Read about these medications. You might not understand everything they're saying about it, but you're going to become a lot more familiar. Those medications tend to work pretty well. Now, if you have a doctor that says it doesn't matter what medication they're on, they're all the same, get another doctor. If you have a doctor who says, well, we have to keep them on this medication for a year before we can change them, and you're looking at some really weird things going on, no, you don't. So you can get another doctor, one that has a little bit more upstairs in the brain department. Listen to what the doctors say. If they don't make sense to you, don't hesitate to get another doctor. Now, if you go in and you tell the doctor, we're just going to do, I'm really into the organic things, and we're just going to do special things and none of this medications, they're going to remove you as the conservator, and rightly so, because those things don't work. And why didn't you do it before you got your LPS if you thought they were so good? So remember, LPS it's basically the main thing is medication. There's one more, clozapine. If they're going to be in a locked facility, that's not a bad one to try, but they do run blood tests to check the white blood cell content. Only 1 out of 100 people have a problem, but they're proactive and they want to check to make sure that your loved one is not one that's going to have a problem with their white blood cell count. And that's a pretty good medication also. Anybody want to add anything?
I think you've covered it.
Okay, next slide. Jim?
Oh, I didn't see. I'm sorry, it didn't come across on my screen properly. So a guideline for medication is to utilize the scientific method. You can't just decide one day that you're going to eliminate 3 of your conservatee's medications, thinking that those types of medications aren't best and that you want new medications on board and that type of thing. Scientific method means that you change one medication at a time. You can titrate a drug and introduce a new one, but only one at a time. Otherwise, if you have 3 new medications, you don't really know what each individual medication is doing for your son or daughter or loved one. If you change it one at a time, and all of a sudden you see a uptick in positive behaviors, clarity of mind, and that type of thing, you know that medication is working the best for your conservatee. So find out which one works the best, then add, if necessary, an additional medication. Again, you need a journal for your medications, write them down, pay close attention to the medications, especially when one's being introduced or taken out in regards to the behavior of your conservatee. Gail, you want to add in your name on it?
Yes, I do. When you're keeping that journal, you're writing the behaviors of your loved one, anything they say and don't say. I like to just add, do not correct things that they say. And I mentioned this yesterday. If you start correcting them and saying, oh, that's not true, that didn't happen, they will not be saying things to you anymore. So you don't want to correct them. If they're saying something really wild, you can say, wow, that's got to make you feel very uncomfortable. I'm sorry you feel that way. Or, I don't quite see it that way. But don't correct them, because even through their recovery, they'll go 3 steps forward, maybe 2 back, which is very disconcerting. And then 3 steps forward and 2 back, or something like that. So you really need to know at all times where their mind is, at what level their mind is. And that is very, very important. So don't correct them. Just go with the flow and let them know, that's got to be tough for them. All right, next slide.
Formulary for medications. If a medication is not listed in the insurance profile, request the treating doctor to write a formulary to request a new medication. Gail was actually explaining this to me somewhere back down the road in time, as well when I had a concern about medication not being available. The doctor in the hospital was saying, don't worry about it. I'll just write a formulary. It's just not a big deal. So again, while the insurance may not cover this up front, the doctor can get approval for that, and we can get the medication started. So ask the treating doctor if they have free samples to try a new medication. That's really helpful. Also, you want to seek out which medications that will help for a serious mental illness. Don't settle for just okay, that's kind of working. You want your loved one back to their old self before they had psychosis. So look for the best medication that's going to work the best for your loved one. And again, enter the medications and your personal observations into your medication journal on your loved one.
Mm-hmm. Look at the old pictures of your loved one. Remember what they were like before they got ill. That is really important. This is what we're seeking, to get them back their life as close as you possibly can. And if you have a doctor who says, well, that's the best you're going to get another doctor. I mean, you really want to work in conjunction with the doctor. And if it's a doctor that doesn't believe in recovery, get another doctor. Okay, next slide.
Placing your conservatee in a treatment facility. An ICD is an intensive care division of Department of Mental Health that evaluates and suggests where the person should be placed. You should really take on the responsibility of touring every facility and ask questions. As a conservator by law, your request for placement facility must be honored as best as possible, unless the criminal court places your loved one in that regard. You should write on every contract your express written permission must be given for any change in medication, treatment, and placement. I'm going to break protocol here for just a little bit. For those of you like our webmaster Mariceli that just bought a new Macintosh, know that if you hold down your Command and Shift key, if you look down at your keyboard, hold those down and then push the number 4 up at the top of the keyboard, you can then place a little cross, on the screen, and you drag that and down, it will capture this statement. So if you have a Mac, I would suggest you do that right now. I've also wanted to be a little bit windy so that we give the rest of you a chance to get this written down. That is so important. I love fine point pens. Intergel cells by Pentel is an excellent pen for that. Whenever my conservatee ends up in the hospital, they ask me to sign the paperwork, and I look at what needs to be added into that, and I just start writing, with fine text. And I write the statement in there that they need my express written permission to change any medications, treatment, or placement.
Jim, I'd like to add, when you go to the treatment facilities, when your loved one's going there, they're going to have you sign papers. And basically, you're giving them the right to treat, medicate, whatever for your loved one. Translated to a lot of these facilities is now they've got the conservatorship. You've given them the permission to do that, and they don't need your information anymore. And so you go to visit your loved one, and gosh darn, they're acting really strange. And you only find out later on they switched their medications. You didn't know that. That's why that statement is very, very important to put on. And if they give you trouble, say, this is what the law is. All I'm doing is putting down what the law is. You need my written permission to do this, not my verbal. It needs to be your written to make changes, because they will push you around if they can. And when you're asking the questions, ask them, if my loved one goes off the medications, do you notify me? That's very important to know. Anything that happens in there, do you let me know? You want to know what's going on, and you should. Now, you don't want to know what's going on in their private conversations with their therapist. They're not going to tell you. And honestly, you don't really want to know that. All right, next slide. Or Jim, did you want to say anything else?
I just am shocked at how uneducated our hospitals and our treatment centers are that's run by our behavioral health care agency. Really don't know the laws. They've asked me to do things in the past that I've had to correct them on, saying, I'm sorry, but I'm exempt from that. I'm a conservatee. It's the law. You need to do some research. So you need to know that you have this right. And if they say anything about that, it's just a heads up that they don't know what they're doing. They are not aware of the Welfare Institution Code or what it contains and how that applies to your conservatee. All right, next slide. I guess that's going to start.
Yeah, that's treatment and placement. Cashmere, that's actually for you.
Oh, for me. Okay. Placement and treatment via hospital. So hospital requests intensive care division, that's ICD, to evaluate the conservatee for placement. Person can only be transferred from a lockdown facility to another lockdown facility. I think we talked about that a little bit earlier. Usually go from locked to locked. Institute for Mental Disease, that's our IMD, is a lockdown facility where the hospital would normally first discharge a patient to. As the patient improves, they might skip IMD and be discharged to an enhanced residential setting. That's our ERS, which is a secure treatment facility, not a lockdown. So that's the normal, usually from a hospital to another lock placement to an IMD to a more open setting as the conservatee gets better. So that's the normal kind of level of care. Let me see if I wrote notes down for that one.
Okay, if I can add something. We've had hospitals tell the people after they've been conserved, okay, we're waiting for an IMD to become available. So we're going to discharge this person to your house and we'll let you know when the bed becomes available. Once you take them out of that hospital, they are not in a lockdown facility and they cannot go to the IMD. So just be aware of that. When they say the jail and the hospital are lockdowns, they can go to the lockdown facility, but do not take them home. And if you're having trouble with a hospital pushing you around like that, you can call me, you can call Jim, or you can call the head of the Department of Mental Health, and they will help you. And Public Guardian will help also. Okay, anybody? Next slide. Treatment and placement via the jail. Generally, it will be in a state hospital, Patton, Metropolitan. There's the Cuscadera further up north, but we don't really get that one. We usually get Patton or Metropolitan. So next slide.
Cashmere, would you like to run with this?
Yes. So normal movement through treatment facilities. So IMD, our Institute for Mental Disease, aka lockdown facility. Next, enhanced residential setting, ERS. That's a secure facility. Boarding care is the least restrictive placement. So like we talked about in a few slides ago, you must go from a lockdown hospital or jail to another lockdown. Conservatees may skip a facility and go to a less restrictive facility as they improve in their recovery, assuming the person is no longer a flight risk. Doctors can request the court to remove you as a conservator. You are responsible for acting in the best interest of the client. So you must be reasonable. You must be able to be contacted, responsive to the treatment teams. The treatment doctor can also request the court remove you as a conservator. You can also change treating doctors. If you find that maybe the doctors aren't speaking to you, giving you the information that you need and require to make the best decision, you can also change treating doctors. But it is important to remember that you are working in the best interest of the client, and if you're not doing so, you can be removed.
Conservatees' loss of rights. Your conservatee, their temporary restrictions for the conservatee is the right to drive a car, enter contracts, and really determine where they live. As they get better and they're under the conservatorship, they can get the right to drive a car, enter contracts, and pretty much determine where they want to live. Now, if the public guardian is their conservator, then most likely they're not going to give them the right to drive the car in their contracts and to make that final decision where they want to leave. But as a private conservator, you can request that right to drive a car, and that's not that difficult. But the court has to approve all of this. More permanent restrictions for the conservatee is the right to refuse a medication. Once they take away the right to refuse the medications, you have no conservatorship. That's the end of it. The right to shoot and possess guns, you really don't want them to have that. But we have had a few court cases where the person has regained that right, and there was specific reasons for it. So, and they kept the conservatorship and had the right to shoot and possess guns. So it just depends on the situation. But you normally don't ask for that right to come back. All right, next slide. To reinstate the rights of the conservatee, if it's the right to drive the car, you write a letter to the doctor stating that you feel the conservatee should be able to drive. They might have a job that they need to drive, and they're doing well enough that they can do this. Remember, our goal is to get them back to where they were. And also Public Guardian's goal is to take away the grave disability aspect. So if they get a job, that would help. The doctor fills out a form, one page, and it's on that paper that Cashmere told us about, or that booklet. It'll be on that paper. They fill out the form for the conservatee to drive, and you submit it to the court. The court approves the right to drive, and usually Department of Motor Vehicles will evaluate the conservatee and approve the right to drive. They have what they call a safety consultation. It's no big deal. You know, do you know your name, rank, and serial number? But people do stress out about that. And then they determine, okay, they can get their license back. The right to enter contracts, you can request that the court reinstate their right to enter the contract. You don't need the doctor for that. Cashmere, did you want to add anything on this, or Jim?
I don't want to add anything. I think you've covered it pretty well.
Okay, next slide.
Oh, okay.
Renewal of conservatorships. So you should always start the renewal process 3 months early, just to make sure that the conservatorship doesn't lapse. If we go over the year, they terminate by law, and the process would have to be started all over again. It's very important to start the process, to give yourself enough time to go to court, get the you need 2 doctor declarations stating the person remains gravely disabled for the conservatorship to continue. So to give yourself time to get everything that you need in place and to get into court, definitely start the process early.
Okay. I'd like to add, when your loved one, if your loved one's placed into, let's say, a long-term facility, and it turns out that the renewal of that paperwork is coming up, and now it's time for you to apply, what are you going to do? Well, I found that you can simply go to that long-term facility and ask them to sign the doctor's declaration form, which they always do. They'll get a second doctor, and they'll get that paperwork back to you. One of the things that I looked at too was when I went to my son's primary care physician. They refused to sign it because they hadn't seen him for so long. I said, well, he's been, in a facility for a while, and that's why. So it's very important that you, as the conservator, keep your son's psychiatrist and primary care physician updated on your conservatee's condition, if they've had relapses, if they've been in the hospital, anything like that. You want to bring that to the attention of the doctor, knowing that at the end of the year, you're going to need their signature on that doctor's declaration form. And if they don't know what's been transpiring throughout the year, they're not really wanting to sign that. So that's really something that you want to think about as the year is passing by. Gail, anything you want to add to that?
Oh, I think y'all covered it very well.
Okay.
Next slide.
Great. So grade disabled, starting January 2026, welfare and institutions code 5800. The definition is a person is gravely disabled if they are unable to provide for their basic personal needs, including food, clothing, shelter, personal safety, or necessary medical care due to now a mental disorder, a severe substance use disorder, or both severe substance use disorder and mental health disorder. So we know that the definition has now changed to include substance abuse.
I just like to add the substance abuse behavioral health in Los Angeles, that group, they're the ones that are helping out with a lot of these facilities for substance use disorder. Mental health, the Department of Mental Health helps with mental health. So you're going to end up actually having to use both facilities and use where if a person has a substance use problem, you want them in both programs at the same time. So they're going to try and work this out together a little bit. They're still working on that. Okay, next slide. Gravely disordered. You can use disorder. Basically, with the food, there are a couple ways, and these are pretty helpful. If they've lost significant weight from not eating, or they're compulsive eating and putting on excessive weight. Both of those are health risks. Refer everything to safety and health risk. And don't put, well, they haven't eaten for 2 weeks or something like that. Don't put times on anything. Just use terms like excessive weight or, significant weight or something like that. Clothing, if they take their clothes off at inappropriate times and places, they don't do that 24/7. But if they have done that, that's a reason for the clothing. Dressing inappropriate for the weather. It's hot outside. They're wearing a sweater, sweatshirt, a hood. That's building up body heat. That's not good. Or it's cold. It's a t-shirt, shorts, barefoot, flip-flops. All those are health risk or safety. Or they wear their clothes for excessive periods of time, building up bacteria on their skin, which can start to cause MRSA, and that's a very serious disease. So you want to, these are possibilities for food, clothing, and shelter. Shelter, you say they have no place to live safely, they cannot handle a board and care shelter or a shelter safely. Now, you only need one. The law is or, not and. So you only need one of these, but you try to hit as many as you can. And remember, refer everything to safety and health risk. Anybody want to add anything to that? Next slide.
Go ahead.
Oh,
Cashmere, go ahead. Cashmere, did you want to say something?
No.
Okay, I was going to. Can we go back to that? Okay. In terms of the clothing and wearing, let's say, a black sweatshirt and black pants and that type of thing, and it's 100 degrees outside, and you say, what's going on with them? If your loved one's co-occurring and they're taking methamphetamine, it throws their internal regulation off, and they actually feel cold even though it's 100 degrees outside. So they'll put on, that's a lot of individuals going back, 20 years on up till today, they like to wear black. That's the in thing. It's a great in the clothing industry. And my conservative is included in that. So that's a big red flag if I see him wearing a lot of black clothing. Of course, there would be other symptomologies too that would be pretty self-evident as well. But it's really dangerous to allow that to go on. You want to get that under check immediately. And in my book, that's time for a 5150 placement in the hospital. Okay, I'm done with that. Thank you.
Conservator's court renewal court hearing. So the renewal can be a court hearing where the judge decides or a jury trial where 12 people decide. The conservatee has a right to contest the conservatorship. So it could either be with a judge or with a jury.
I'm going to add something on that jury trial. If you're doing a jury trial, and let me tell you, that's quite stressful, there will be an attorney that you can work with, and y'all pick the jurors. They call the jurors out, and you can say yes or no. You get, I think, 9. You can say no to or something like that. Ask the attorney that you're working with how to eliminate without asking for Scientologists. They do not believe in involuntary treatment. So you really don't want a Scientologist on that jury. You also don't want the people, which is pretty easy to spot, the piercings all over their body and tattoos, because chances are they don't believe in that either. Maybe they do, but your probability is pretty great that they don't. And the attorney will help you on the selection for the jury trial. This is if you are the conservator. If you're not the conservator, it's, whatever it is. So, and sometimes the judge will rule out certain people because he'll ask them questions. And I was in the courtroom one time when one guy sauntered up, and the judge says, I need to ask you, do you understand what a conservatorship is? Yes, sir, I know all about that, sir. That's about money, ain't it, Your Honor? It's all about money. They're trying to conserve me. And the judge says, okay, next, So It's interesting. Let me put it to you that way. Next slide.
Conservatee goes AWOL. I've had people call me from out of state on this one. You want to immediately file a missing persons report. You don't have to wait for any time frame or period of time to pass before you can call that in. Anyone that has a disability of any sort of nature, especially things like mental health and so forth, the police are required to take a report immediately and initiate a number of different responses, statewide and locally as well. So you want to give a copy of your conservatorship paper to the police. Let them know that you are the conservator and what your authorities are. And believe me, they won't know what the laws are on conservatorship. But so your conservatorship papers are there to show them that you're court appointed. Any person with a serious mental illness goes to the top of the missing persons list under missing children as a dependent adult, does not need to be under conservatorship. So again, Outpost for Hope is a site that I had stumbled over some time back in time. And I've gotten to know them personally, over the phone over the years. It is a go-to place, whether your loved one's missing or not. I recommend everybody in our audience right now, write that down, outpostforhope.org, so that if your loved one goes missing, it will tell you what to do. More importantly, look at it currently and realize that there's things that you need to do proactively starting today that you want to put in place, such as, and Gail likes to talk about the fact that if you take hair clippings and you put it in an envelope, and I'll let Gail talk further on that, but I've actually had families not know if their loved ones are alive or dead. There are literally tens of thousands of missing John and Jane Does buried in unmarked graves across America. I've dealt with a lot of families whose loved ones run off. We'll find them out of state, and we go through this whole process of getting them back again. It's really important that you look at this website. It's important that you take some DNA samples that you can hold, because if your loved one does go missing and something should, heaven forbid, happen to them, you would want to be able to provide that to law enforcement so they can identify whether or not somebody may or may not be your conservatee. Gail, do you want to run any additional information on that?
Yes, I do. When you put it in an envelope, don't seal that envelope, because then mold can start to get that. But if you can get not just the hair, but if you can get the root of the hair, you don't want to jerk it out of their head, but look at the hairbrushes. Sometimes you have that on it. Put that in an envelope, but don't seal it. Now, let me just say, in Los Angeles, there are 4 detectives to help find the missing persons. They don't go out looking for them. They check the jails to see if they've been arrested or something like that. They'll do that. They cannot check the hospitals because of HIPAA. But you, as an individual, you can go libraries. A lot of these people, they will hang out at libraries. And if you have an idea where they are, you can go, like, let's say Santa Monica, go take a picture of your loved one, ask people around there, ask the homeless. The homeless know everybody on the street, and they're very, very helpful, especially if you give them some food. But ask them, have you seen this person? And if they tell you yes, where were they? When were they there? If you see your loved one, it's wise not to let them see you. If they see you, they're gone someplace else, because remember, they're trying to lose you. Keep an eye on them. If they do anything that you could possibly get them back in the hospital, now if they're under the conservatorship, you can do that. They can tell you that. But if there's anything they do, you can call and have them come and put them in the hospital. Now, if they are not under the conservatorship and the police find them, they can call and let you know that they're okay. but they cannot tell you where they are. But the police can tell you where the police are. So you can say, look, I'd really like to get you a cup of coffee or pay for your lunch or something. Could you tell me what corner you are? Is there like a Denny's or something nearby that I can call in and let you get lunch and I'll pay for it? That way you know where they are. But there are different little things that you can do that can help you find your loved one and get them in the hospital. Now, if they're under the conservatorship, the police can call you and say, what do you want us to do? Take them off to the hospital and they can let you know. All right, next slide.
I want to add one more thing. What I have found out is that some of the police departments don't know what the laws are in regards to missing persons. And I'll give you an example. There was a mother in Arizona that had a son with 2 biomedical degrees in biomedical engineering, had gone missing, and she was trying to get a missing persons report filed in Anaheim because she had heard that someone had seen her son in that vicinity, or thought they had at least. And so consequently, when she called the Anaheim Police Department, they refused to take a missing persons report because she was out of state, and they said they could not. She has to be in state in their county in order to file a missing persons report. I contacted Chief of Police, who was in charge of CIT training years back in another city, and talked to him about this, and he said, no, they have to take the report irrespective of whether they're conservative. And I know that some of the conservators here in Orange County and LA County are actually out of state, and that's why you need to know what I'm saying, is that if you're finding out that your loved one goes missing, you have the legal right to file that missing persons report. And so consequently, after the chief had contacted the other chief in the city of Anaheim, they made sure that that missing persons report was in fact filed, and they found them because of that report. So it's very important that you know what your rights are. And if that happens to any of you, you're welcome to call me and I'll work on your behalf with the various police departments to get that file for you.
And just one more comment. If they're in a facility and they leave the facility like an IMD, the IMD is supposed to file the missing persons report or whatever facility they're in. But don't hold your breath. Sometimes they don't. Think on that, okay? All right, next slide.
Leaving the state of California. LPS conservatorship is specific to the law for California. You must have court permission to leave the state. So for example, if you want to go on a vacation or take the conservatee to visit family somewhere else, the court has to give permission for that to take place. California presently does not have reciprocity with other states. You can't leave. You can have conservatorship here and leave and have conservatorship in another state. That's not how it works. So if you do leave, the court should be given permission for that to happen.
Cashmere, let's say you take your loved one out of the state and you have court permission, and they go AWOL.
Yeah.
Will the court bring them back to California? I mean, if you file a missing persons report, will they bring them back to California?
That's a good question. I would imagine that.
I mean, why would you have the court's permission if they're not going to do anything?
Right.
They can go, but I mean, I would think they would be able to. Maybe,
but I don't know how they would exactly. How would they manage doing that?
If they find out, if they find the person, I would think they might be able to. That's something we should check into.
I'll write that down and get an answer next time.
Okay, thank you. Next slide.
So we're at the end of our presentation today. I think this is the last slide. Anyway, thank you, all of you, for your determination to look after your loved one. And I just so admire your endurance to help them and stand by them. Years ago, when we found out that our son had a mental health condition, he was in a facility here in Orange County, and there was a doctor that was getting to retire. He had white hair like mine. And he pulled me aside and said, I want to talk to you a minute, Mr. Farell. He said, I want you to know that when somebody has a mental health condition, it's generally lifelong. And I've been in this business for a long time. And what I have observed is that the families that stand by their loved ones and don't give up, usually it's those family members are the ones that make it. It's when the families don't give up on them. So he said, I encourage you to just hang in there. And you guys are hanging in there. As Gail has often said, when you think that you've had enough, you just can't take this anymore, you can still give 10% more. That's the Navy SEALs model. But then the Navy SEALs haven't walked in our boots, have they? So keep strong, take care of yourself. You know, it kind of goes back to being on an airplane, the window blows out, the oxygen's depleted, the air mask dropped down. You've got a young person sitting next to you that doesn't have capacity to know how to put it on. You put the mask on yourself first. Your thoughts are, oh, I have to help them. I have to get the mask on him. Well, chances are you'll pass out and you'll both end up perishing. So number one is you take care of yourself first and then you put the mask on the child. In this case, we're not talking about children. We're talking about our loved ones. You got to stay strong, stay plugged into NAMI Urban Los Angeles, or whatever community that you're involved in. Just know that you've got more in you to give than you can realize. The Navy SEALs model, again, is respectable, but you guys deserve a medal for what you're doing. It's a tough road, so I wish you all well in that endeavor. Okay, next slide.
That's for you, Jim.
It says Gail on there too. Listen, today's class is made possible by NAMI Urban Los Angeles. It's not fun to ask people for money, but you know what? If you can give a donation, that's what's going to keep these classes going for the next group of families just like yourself that need to know this information. So please, you know, if you can, remember Macintosh Command-Shift-4, click and drag a box over this information. It will screen capture it for you. But if you can't remember this, then go to NAMIUrbanLosAngeles.com and consider making a donation. And if you would, please earmark that donation for this, support group for the conservators. It would be immensely appreciated. What we don't want is if you're, in retirement and you're living from paycheck to paycheck and so forth, we don't want a donation from you. It's just, please don't. But for those of you that can, it's going to help so many more families, and we'd appreciate whatever you can consider. Okay, I think that's it.
Yeah, I just want to thank everybody for coming to this. I mean, you guys are actually amazing. And the thing is, with help,